Representative Larson.
Here.
Representative Sherwood.
Here.
Representative Stith.
Here. Here.
Representative Walters.
Here.
Representative Swanitzer.
Here.
Chairman Nicholas.
Walk us through this bill. Thank you, Mr. Chairman and members of the committee. I'd like to give you some brief history on the origin of the bill and the need for the bill, and then we'll turn the explanation of the bill over to Kit Wentland, who is in the governor's policy office, and as well as Vice Chairman Mike Hute, who is here with us today. Vice Chairman Hute, we appreciate you being here. He's the Vice Chairman of the Eastern Shoshone Business Council and come down to help us work this bill, as well as along with Director Nesvik and his crew from the Game and Fish. So committee in 2014, an enrolled member of the Crow tribe in Montana shot elk out of season in Wyoming in the Bighorn National Forest north of here, and Wyoming Game and Fish pressed charges against the individual and claimed as a member of the Crow tribe, he had a right to hunt as authorized by the Crow tribe's 1868 Fort Laramie Treaty. The case was heard in district court in Sheridan. It was appealed, ended up in the Supreme Court. The Supreme Court ruled in part that in favor of the individual and the treaty rights, and part of it is back in district court. The interesting thing, if I may, Mr. Chairman, is the basis for the claim of the individual in the Crow Treaty in 1868. There's an Article 4 in their treaty that says the Indians herein named agree when the agency house and other buildings shall be constructed on the reservation land, they will make said reservation their permanent home, and they will make no permanent settlement elsewhere. Then it says, but they shall have the right to hunt on unoccupied lands of the United States so long as game may be found thereon, and as long as peace subsists among the whites and the Indians on the borders of the hunting districts. Interestingly enough, when the Supreme Court ruled on this, the language found in that treaty is also found in the 1868 Fort Bridger Treaty, which governed the treaty between our Eastern Shoshone tribe and the Shoshone-Bannock tribe that are in Idaho. And it says, in essence, the exact same thing in their Article 4 of their treaty. So then, since the Supreme Court ruled on this, the state, we've contemplated what ramifications and how we could probably best address possible outcomes of the court case, and how the state could be proactive in having these conversations with within the state with our tribes here in the state, particularly the Eastern Shoshone tribe, as well as others who are impacted by their respective treaties. It was a little difficult to anticipate how we should move forward until the court case is completely settled. This last year, the Eastern Shoshone tribe approached the governor's office and inquired if they would be, if the state would be willing to work with them in pursuing some kind of off-reservation hunting language that would allow this to move forward. And since that time, the Eastern Shoshone tribe and the governor's office, along with their Fish and Game and our Game and Fish agencies, have worked together to put some language in that both the Eastern Shoshone tribe and the governor's office feels is an appropriate way to move forward. What we've been concerned about all along is if the state does nothing, the decisions made could come from the court and tell us how we would need to address this moving forward. And so just really can't express enough how important it was and how much we appreciate as a member, as the chairman of the Tribal Relations Committee, the Eastern Shoshone Business Council reaching out and working with the state to move this forward. It was really a significant effort and one that we appreciate. So with that, Mr. Chairman, and with that brief background, I'd like to turn the explanation of the bill or to Mr. Wetland, and then we can hear from the agencies as well. And Mr. Vice Chairman, you.
I want both of you to come up, introduce yourselves, and welcome.
Good morning, Mr. Chairman. If I might, I think there's a couple of additional items of background that are really important for context here before Mr. Wetland goes through the bill. So, you know, one of the questions that may be on folks' mind is, so what have we been doing for the last 100 and some years since Wyoming achieved statehood? And there were actually two court decisions, one in 1898 called the Racehorse decision, that essentially became the law of the land in, as far as case law, stating that when Wyoming achieved statehood, that those treaty rights no longer existed for off-reservation hunting. That decision was basically reaffirmed in the mid-90s in a decision called Repsis. And so for many, many years, that was the law of the land, and that's what we followed. And this recent Supreme Court decision was weighty and made some pretty significant changes to major components of those previous decisions. That's why we're here today, because that essentially what the Supreme Court ruled recently in the Herrera case was that those treaty hunting, off-reservation hunting rights were not extinguished at statehood. Significant departure from the past. And so that has brought us today to where we feel like we need to have some discussions about a bill that will put us in a position to be proactive and not continue to allow litigation to shape the state's policy on and how we deal with this.
Chairman Nicholas, members of the committee, my name is Kit Wentland. I'm special counsel to the governor, and I also work as the governor's tribal relations policy advisor. Just with that background, I'd like to provide a little color on the current Herrera case and then dive right into the bill, if that's okay with the committee. So the current Herrera case as it stands, it's in circuit court. There are a couple issues left for consideration by the court that the Supreme Court did not decide on, and that is with this right that the Supreme Court has said exists, there are a couple arguments about how it may be regulated by the state, and they fall under whether land where the hunting occurs is occupied or whether regulation by the state would be necessary for conservation. There's not a clear definition of either term at this time. There's some indicia from the Supreme Court decisions, but where it likely leaves us is that to prove conservation necessity, it's a significant burden by the state to prove on a case-by-case basis, could be area by area, regulation by regulation, taking into account the regulations in place, the species, the climate, the seasons in place, the location, a very broad factual record. So not an easy burden and not one that would be decided for the whole state by one case. It would end up likely in many court cases. With the Herrera case in this current stage, an evidentiary hearing on that is scheduled for March at this time. However, another intervening factor has happened. Mr. Herrera, in a separate unrelated criminal proceeding in Montana, he just pleaded guilty to 3 felonies for sexual abuse of a minor related to possession of child pornography. Because of that, he's likely looking at years, if not decades, in prison. That could affect the case moving forward for the state, how the state proceeds. We don't yet know, but thought it was just a fact that the committee should be aware of about where that case is while we're looking at this bill. With this bill, I'd just like to just dive right in and go page by page. So starting with page 1, I think one important thing to emphasize about this bill is this deals with off-reservation hunting. This does not deal with the state attempting to regulate hunting on the reservation. State's authority to do that is, I don't think there is authority to do that. And this deals with this off-reservation hunting right, not hunting on the reservation. Going to page 2, we get into the guts of the bill. Section A really encapsulates what this bill does at base. It's a bill giving the governor the authority to enter into agreements with tribes to resolve off-reservation treaty hunting, trapping, fishing, gathering rights claims on federal or on lands located within the state. And again, I think another important thing to emphasize here is that this bill, if passed, all it deals with is the governor's authority to enter into these agreements. These terms do not by themselves bind a tribal members off-reservation hunting activities. The thought is the governor could use this authority to enter into an agreement that a tribe would work with us on, first the Eastern Shoshone, to define how that process would work in a cooperative and collaborative way. Going to section B, any agreement executed under this section would have to be written, signed by the governor and the designated authoritative body of the tribe. The tribe would let us know who that appropriate body is. Going down to section C, this is where it gets into the sideboards on what the governor's authority would be to enter into any agreement. So while this is, in a sense, broad authority, there are important sideboards that would be placed on it to help ensure uniformity of agreements more to the best extent possible, as well as assure that the state can protect shared values that both they and the Shoshone have. And it's at this point that I think it's important to emphasize a couple points. The Eastern Shoshone came to the governor's office in April of last year, asked to speak about off-reservation hunting in the wake of the Herrera case. And from those discussions spawned a discussion about shared values. And 4 important shared values were talked about that both the tribe and the state share. The first one is just the idea that conservation of wildlife is important. The Wind River Reservation has a tribal game and fish code that has helped game come back from a pretty desperate spot. And currently hunting on the reservation, from what we've been told, is very good. The second of these important shared values is a mutual respect for tribal sovereignty on the one hand, and for the state's authority to regulate hunting off the reservation on the other hand. And it's a balance. The third.
Kate, would you repeat that one again for me, please?
Just a shared value of recognizing tribal sovereignty over their rights and their treaty, while at the same time recognizing the state's existing regulatory, hunting regulatory sphere off the reservation. The hope is to bridge the gap between those two through an agreement. The third shared goal, the goal of managing and preserving the opportunity for responsible hunting by current and future generations. For Wyoming citizens, the ability to hunt is enshrined in the Constitution. And it's important for the state, for its children, and future generations moving forward. And it's the same, it's the same for the tribe as well. The fourth goal is helping habitat and wildlife thrive through scientifically based management. So through these discussions, the governor's office, the tribes, and legislators were able to come to agreement on this draft. And I just wanted to emphasize again what Representative Larson has said. When there's a partner willing to work with us on an agreement like this, it is much better to be proactive and make a good agreement than to wait and risk a bad court decision. So going through the sideboards in this bill, the first one would be on page 2 of the bill, section C, Romanet 1. The agreement would have to be consistent with existing state statute. Under Romanet 2, there would be agreement that the tribe adopt a game code or other similar enforceable regulatory mechanism that provides for the issuance of hunting, fishing, trapping licenses and adopts or incorporates the substantive requirements and prohibitions contained in these statutes, 23-3-101 through 3-407. Those statutes are not the entirety of the Game and Fish Code, but they are the guts, the foundation, kind of the pillars that we're looking at. So things like hunter safety, hunter's orange, in that basic area. Those are also enshrined a lot in regulation as well. There's a lot, but those provisions are foundational pieces of the state's regulatory framework. Romanet 3, the governor would have to find that the tribe has the ability to effectively enforce the provisions of its game code against violators through likely something similar to a game warden system where they have a code that they enforce. Romanet 4, the tribe would agree that tribal members who do not possess a valid license would be subject to regulation under applicable state laws for acts committed outside the boundaries of the Wind River Reservation. There's a lot to that sentence, but what it boils down to is the talisman of what is enforceable boils down to, do you possess a license? If it's a tribal license, then we're probably talking about a tribal off-reservation code. If we're talking about a state hunting license, then it's a state code. And if there's no license at all, then we're looking at a state, then we could be looking at state enforcement. However, the mechanics, and this is going into this next section, the mechanics of enforcement, those specifics are things that we'll have to work out in detail with the tribe through negotiations. At this time, these broad, high-level items are what we've talked about, and we have yet to really dive into the details in those negotiations with the tribes, though those conversations are on the horizon and both the tribe and the state are ready to have them, I believe. Romanet 5, this is where it gets into the idea of if you have a tribal, say you have a tribal off-reservation hunting license, this bill provides the flexibility for the state to discuss and negotiate with the tribe how the enforcement mechanism for that works. It would likely involve a tribal game warden, and there will also, but we will discuss the details of how that actually would work day to day with the tribal business council. Going to Romanet 6, this gets into the parts of state hunting that probably will seem more familiar. A tribe in an agreement, if the governor were to negotiate into agreement, the tribe would agree to align its hunting, fishing, and trapping seasons with the state seasons set by the Wyoming Game and Fish Commission. However, except for limited exceptions for ceremonial or religious purposes, there are certain ceremonies, purposes in the spring or summer. I don't know all of the details, but that where a limited take of a few animals would be requested by the tribe, and it's something we think we can work with. Section B here, tribe would abide by hunting, fishing, or trapping area closures. And I think that's in the interest of all parties involved, so that you can say, look, there's an area that needs to recover. We want to close it so this population can recover. And there's the ability to coordinate that with the tribe through the agreement. Section C, an agreement for the tribe to collect and share harvest data with the commission. Section D, setting appropriate quotas, daily limits, and possession limits. This really centers on harmonizing how these quotas will work through these areas and making sure there's a way that the tribe and the state can harmonize how their quota system work, not have competing headbutting quoting systems. And then going down to Romanet 7 on page 4, the agreement provides that tribal hunting, fishing, trapping, and gathering shall be subject to the state's right to regulate when necessary for conservation. Again, this deals with off-reservation hunting. This is not on-reservation hunting. And this really gets to the fact that instead of fighting about conservation necessity in court, this agreement is standing in place of that argument. This agreement is the state and the tribe's agreement about how they're willing to mutually manage this resource and these competing rights. So that argument in court is not basically the parties are saying, we're not bringing this to court to argue a competing system. Section D just reinforces the fact that we're talking about the unoccupied lands of the United States. That's the language in the treaty where the tribes have the right to hunt. And that does not include under any of these agreements, private land. The governor would not have the authority to negotiate an agreement where a tribal member or anybody for that matter could hunt on somebody's private property without their permission. Unoccupied land of the United States It's not exactly defined. It likely does include national forest after the Supreme Court decision and some BLM land. And then outside of those confines, there's still court to court, you could probably get different answers. Going to section E, we define the term gathering. Gathering is called the sustainable non-commercial collection by hand of naturally occurring vegetation or non-mineral surface materials for personal, ceremonial, traditional, or religious use. Does not mean the harvest of fish or wildlife. These.
Thank you, Mr. Chairman. Going back to the open lands, and this doesn't apply to the private property. How will it apply? And so then you discuss Forest Service and BLM, which is federally owned. How will it affect the state-owned property, the state sections throughout Wyoming?
Chairman Nicholas, Representative Walters, state land. So there's a lot packed into the phrase unoccupied land of the United States. Of the United States indicates to us that it does not include state-owned land managed by the Board of Land Commissioners. Could the state negotiate something about that? It could, but unoccupied land of the United States under the court case does not include that land. It would include federal land. The exact confines of that federal land, I just can't give you a map here today, but after the Herrera, we know it includes Bighorn Forest, unless there's a residence located there, and it likely includes BLM land as well. Gathering, this definition of gathering in section E, what it's getting at is the ability for a tribal member to go and pick and gather, whether it's, there's a whole list of plants or berries or artifacts. We're not talking about protected materials, just the ability to say to go gather choke cherries that you want to make jelly for your family. Or if you want to gather some sort of other plant material, the ability to go out by hand, collect that stuff, not for a commercial purpose, not minerals like oil or coal, but these kind of basic, you're going out on land and collecting material. A lot of that, there might be a right to do currently, but the ability to negotiate and speak about that is just what we want to preserve because we've been told it is important to the tribe to be able to speak about that in an agreement. Tribe, here the last definition. This references 20-5-202, and that definition defines tribe as any federally recognized tribe. That's the statute we have that defines tribe, so that was why it was used. This bill would allow the governor to separately negotiate an agreement with tribes upon first speaking with them and determining that there is a hunting right, off-reservation hunting right that exists. And the Eastern Shoshone are the first that have approached us to speak and are likely the first that we would speak to about this for an agreement. Going through the rest of the bill, section 2, the governor would report to the joint TRW committee after an agreement was entered into within 10 days of completion of an agreement. Section 3 provides rulemaking authority necessary to implement an agreement. First to the Game and Fish Commission, as they're the agency that would most likely be involved. The Game and Fish Department will be involved with us in all negotiations, and they're the agency most affected by rulemaking. The Board of Land Commissioners, because we may be talking about things like gathering on state land, and the Board of Land Commissioners is the one with the regulatory authority over state land. And then section 4 is making the act effective immediately upon completion of all acts necessary for a bill to become law. I guess in sum, I just want to emphasize that the governor really appreciates his collaborative relationship with both tribes and really respects the open line of dialogue he has. And we can't express enough our appreciation that the Eastern Shoshone tribe was willing to come speak with us and work with us about this bill. When you have a partner like that willing to collaborate and work with you on something like this, it is much better to take advantage of that relationship, to work with them, and to come to a good agreement instead of fighting it out in court. With that, I would stand for any questions.
Please, go ahead.
Okay, that definition of tribe is in child custody hearings, and that's the one, and correct me, just wanting to for my own edification, I believe that's the only place where we really define tribe in our state statutes, and that is because of the Indian Child Welfare Act, where and how that plays into child custody hearings and recognizing and defining tribes as a means an Indian tribe or band or Alaskan Native village, which is recognized by federal law or formally acknowledged by the state.
Chairman Nicholas, Representative Larson, that is, or Vice Chair Larson, that is correct. That's the only statute that really defines tribes in a definition section like that. And I think that is correct.
Representative Henderson.
Thank you, Mr. Chairman. Just a real quick question, Mr. Chairman. My assumption is that this will apply only to people who are enrolled members of the tribe. Is that correct?
Chairman Nicholas, Representative Henderson, for each treaty right, so for say the 1868 treaty speaking with the Eastern Shoshone, any agreement would only apply to their enrolled members because we would be negotiating with the Eastern Shoshone separately.
Mr. Chairman.
Go ahead.
But in fairness, and I think it's important for the committee to recognize that as the Eastern Shoshone tribe come forth and helped author this approach, we're giving governor to negotiate with any tribe who feels that they have a treaty right to hunt, but it would be done individually, and their agreement would be specific to their tribe. Is that fair?
Each tribe we would speak with would be speaking about their enrolled members after determining, of course, that there's an agreement between the state and that tribe on the existence of their off-reservation right.
So for the questions, so I take it that detailed discussions, breaking this down, have not really occurred yet. Is that fair?
Chairman Nicholas, we've had a lot of discussions about this bill in terms of the details of how each piece would work. That still does need to be negotiated.
For example, the definition of unoccupied will have to be in some mechanism. You'll have to come up with a definition.
We will have, Chairman Nicholas, we will have to speak with the council about the extent of that.
And you'll have to come up with definitions of the, I think the term is what is the hunting districts or hunting areas?
Chairman
What's
Nicholas.
that term of art?
Oh, apologies for interrupting. In terms of unoccupied and its interaction with hunting districts, I think we will need to speak with the tribes. First with the Eastern Shoshone Business Council about what those mean, where those are. I will say there is some direction from Supreme Court decision about the term unoccupied and what it means in the Herrera case. Those are definitions that we will of course be referencing, but the extent of how that interacts with that hunting district language, I think we will need to speak with the tribe about.
And so I'm curious, obviously, this will open up a broad swath of ground across Wyoming. And in order to enforce hunting regulations that are tribal regulations off the reservation will require, I would think, quite a bit of personnel to be able to cover the range that hunting may exist or may be authorized. Have you had discussions with the tribes about how they would be able to effectuate that? Because it's an expensive proposition, both time and equipment and just the breadth of the grounds.
Chairman Nicholas, and I don't want to speak too much on behalf of Vice Chair Ute and the council. At a high level, what I can say is there have been some discussions about how that would work. There is a thought of a separate Eastern Shoshone off-reservation game warden system. There is not at this time anticipated to be a glut of off-reservation hunters. There will probably be some, but we have had at a high level those discussions. The tribe believes they can handle them. The details of how that would work and how it would interact with the state system, those do still need to be negotiated.
Go ahead.
So a little bit of maybe we could get Director Nesvik to help us a little bit, because I think we kind of do that now. I mean, I could apply for a limited quota permit and get that, or a draw permit, and I could get that a long ways from Lander. And the requirements to ensure that I go into that specific geographical area and harvest that game according to rule and law is governed how, Director? I mean, I don't have to go and have you or somebody accompany me unless it's buffalo in the national forest, but I don't think it would be a whole lot different than the way we operate now, would it? Do you help us understand that?
Mr. Chairman, Mr. Vice Chairman, so I think you're exactly right. I mean, right now, we provide coverage in all the areas that would be unoccupied lands in any kind of an agreement that we made with any of the tribes. And so the details, though, that would be required to be negotiated would be exactly how that interplay happens between state game wardens, tribal game wardens, and ability to enforce tribal game code versus state game code, no matter where it was in the state of Wyoming. And I think the other thing that's important here is, each tribe has its own nuances and its own complexity. So right now with Eastern Shoshone and the Northern Arapaho, they're Wyoming resident citizens. So they actually today have a different, without any bills passing, without any treaty right, they have a different set of circumstances than, say, the Crow do. So a Wyoming resident citizen, an Eastern Shoshone enrolled member could go and apply as a resident for a general license and go hunt in any general license area in the state, whereas a Crow member could not, because they're not residents of the state.
Well, and Mr. Chairman and Director Nesvik, I think I understand that. I guess what I'm really suggesting that is if I got a permit to go down the Sierra Madre, long ways from Lander, I may or may not ever see a game and fish warden. I know that they're there, but in my years of hunting, probably 1 out of 15 times do I ever actually see a warden during the day, other than when I come back in and stop at the check station. So I think the ability to say coverage, if a tribe had the ability to hunt in the state, I wouldn't think it would be tremendously unlike what we currently do now. There would be rule and regulation, and they'd have to comply with those. Am I seeing that differently than you envision in your mind?
Mr. Chairman, Mr. Vice Chairman, I think you're right. And I do think that, there's going to be certain areas that particular tribes are going to focus on. We've been told that by Eastern Shoshone, that they're, really they think it's likely that if there's an agreement reached, that most of their enrolled members would probably not exercise it, but the ones that would do it fairly close to the existing reservation. And I think you'd find the same thing if there was ever to be an agreement with, say, the Crow. They're probably going to be focused on the north end of the Bighorns for the most part. So I'm agreeing with you, providing a little bit more context.
So my question is, based upon the early treaties, how many various tribes theoretically would have that portions of Wyoming would be in the established hunting districts of the 1900s, and how much of those overlap? So how many tribes and how much do they overlap?
Yeah, Mr. Chairman, so there's a lot of different tribal treaty rights. The off-reservation hunting treaty rights that we've really been focused on, that we're mostly aware of, involve 4 different tribes: the Crow, Shoshone, Eastern Shoshone, and potentially the Northern Arapaho, but a different treaty right there. And that's really it. There are other tribes that have treaties in other parts of the state, but a lot of those were very specific to, say, like bison, and don't have the same components as the 1868 Fort Laramie Treaty.
And so I'm just trying to think of logistics. So let's just say you have 5 tribes that fit that definition. So each of the 5 tribes would essentially theoretically have their own game wardens and their own tribal code that may differ from the others. And so enforcement would be, how do you visualize enforcement? Would this be a cross-jurisdictional enforcement? So the game and fish would work with the tribes where necessary. How do you envision this working?
Mr. Chairman, I think you're exactly right. It would be specific to each individual agreement. It would be some cross-jurisdictional authorities for both the tribes and the state. And that's how other states that, there's other states that have a lot of these different types of agreements and treaty rights. And that's how they've tackled this. The Eastern Shoshone as an example have even talked about there's not a lot of enrolled members. The number's not very high. And they've even talked about sending a tribal game warden with their members when they were off reservation if we were to get to some type of agreement. So I think there's a pretty wide, broad set of pathways that we could, achieve the enforcement that we need to achieve depending on how these agreements are written.
Go ahead.
Along that line, Director Nesvik, if I understand on page 4 up there at the top, if there was an out-of-state, let's just say the show bands over in Idaho, and they may have a season that is just a little bit different than ours in Idaho. But this is saying that if they were allowed to hunt off reservation in Wyoming in traditional hunting areas, that it would have to comply with or align more so with what we do in Wyoming rather than perhaps what they do in Idaho.
Mr. Chairman, Mr. Vice Chairman, that's exactly right. The agreement would be bound by these parameters. And so you're exactly right. Have to comply with whatever the Wyoming game and fish regulations are.
So for example, would an Eastern Shoshone who lives in Montana or South Dakota, would he have an out-of-state license? So an additional fee as opposed to a residence license when hunting in Wyoming, or have you crossed that bridge yet?
Yeah, Mr. Chairman, I think the way that would conceptually work is they would have a tribal license issued through the Eastern Shoshone Tribal Council.
And so the tribe would have the authority to say, we want a cheaper price for our residents versus our non-resident tribal members.
Correct.
If they chose to, basically.
That's correct.
Mr. Chairman,
Go ahead.
can we ask Vice Chairman Ute if he joined it? I got a couple of questions, and I know he probably has some things, but I'm hoping he can help me understand a couple of things.
Welcome, Vice Chairman Ute. Welcome. Thank you for being here.
Good morning, Chairman Nicholas, Vice Chairman Larson, members of the committee. Glad to be here.
Vice Chairman, you just on, so the reason this bill is here is as much authority as the governor has, he still doesn't have authority to do this unless we grant it to him. And so then I was just curious in that section on where it talked about on page 2, where it talked about the agreement needs to be executed in writing and signed by the governing body of the tribe. Can you just help us? I think you would just have a better understanding of how that looks across Indian nations, what those authorities is that always with the business council? Is it with is there perhaps like a president? Is it a general council? I'm assuming that it's not uniform across sovereign nation to sovereign nation. Can you just give us some examples of how those might look?
Yeah, Chairman, Vice Chairman. So that will vary across different tribes. Currently, the Eastern Shoshone tribe does not have full authority over off-reservation hunting because the general council, the people voted for a separate committee to basically regulate what off-reservation hunting would be. So that they have the authority over that. So it depends upon the tribe what they want. Maybe the business council or the tribal council will have the authority to enter into negotiations. I just don't know. I can't speak for those tribes.
So
Those are some of the examples.
Can I follow up on that? I think you need to go back to Shoshone-Eastern Tribes 101 and tell us what the business council is and tell us what the general council is and what the differences are.
Okay, so the Chairman, the Business Council has been elected by the people to run the day-to-day operations of the tribe, the business relations of the tribe. That's why they're called the Shoshone Business Council. So day-to-day operations, whether it's tribal programs or anything that requires immediate action upon the land, things like that. The General Council is the people when they establish a quorum, much like a legislative session. So if they establish a quorum, they can act on certain agenda items. They can pass. What that essentially does is it gives direction for the Business Council to accomplish because General Council only exists when it makes quorum, and that's 4 times out of the year. Other than that, it doesn't exist. It only exists when it makes quorum to when it adjourns. This is where the Business Council steps in and has the authority that the General Council then gives to it.
So in this instance, it would be the general council that would adopt this agreement with the governor. Is that correct?
Not currently, because General Council did already appointed a off reservation hunting committee, and that committee, which I think has 3 or 4 people on it, that would then have the authority for the agreement itself.
Go ahead.
Thank you, Mr. Chairman. So if the general council disagrees with the parameters that the committee agrees to, how would that be resolved internally?
Mr. Chairman, so Representative Walters, we also have to remember before we wade too deep into the waters here that this bill is just for the agreement. So that, of course, that could happen. If this bill passes, of course, that could happen. Of course, the governor could disagree and walk away from the table. The tribe could disagree, walk away from the table. Both parties could do that. So I can't say for sure General Council will agree or disagree, or the committee would disagree, or even the Business Council.
Mr. Chairman,
Go ahead.
don't think I asked my question properly. If the committee that the general council has appointed to work on this issue agrees to do something with the governor and everybody's happy and that's all moving forward and signs off, but your general council disagrees with what that committee has done, what's going to be the ruling there? You know, will it nullify what's been decided because the general council doesn't agree with what the committee had done, or how does that work?
Yeah, Mr. Chairman. So if the committee makes an agreement, everything goes through and they have the authorities to do that, the General Council can probably bring it back on a separate agenda item. But again, that committee would have the responsibility to show up at General Council to represent themselves and say, this is why we did what we did. And then it would be up to the people to decide if they're going to disagree with that decision or not.
And Mr. Chairman and Vice Chairman, that's probably more just as a question to help us better understand how it works through your governmental proceedings more than it applies to this bill. We're just curious.
And Chairman Nicholas,
Go ahead.
I just wanted to emphasize a point that Vice Chair Ute mentioned. You know, this provides authority. It does not create an agreement. And so the governor or the tribe, for that matter, we still have to work out the agreement and come to that agreement. And so I think that process of negotiation will probably hit disagreements and have to work through them. That process is still coming. This does not bind anybody to an agreement at this time.
So, Mr. Beltman, one of the issues obviously with this bill is it kind of takes our process and turns it upside down. Because typically we, meaning the legislature, are responsible for the laws of Wyoming. We draft the laws. We decide what those laws are going to be. And then our governor, as the chief executive, is responsible for implementing those laws. With this draft bill, we basically, as the legislature, assign that responsibility or we abdicate it to the governor to work directly to develop laws that impact of the citizens of the state of Wyoming that then have not been approved by the legislature, but rather are established by the governor and by the executive committee in along with and through the negotiations with the tribes. And so what I'm wondering is, will our body, the legislature, agree to give up the ability to do something similar to what the general counsel has the power to do? And that is say, once you've done all your negotiations, you've worked with the game and fish, you've created draft rules and regulations to implement this, then bring it back to us. And we will then, we being the legislature, say we approve or we disapprove of this, and we enact it into law rather than it being an agreement through the governor, which typically he does not have the authority to do unless we give it to him. And so to me, that's the primary hurdle that I see in this draft bill on how we want to proceed in that. Or, and it's so, at any rate, do you have any comments on that? And also to you, Mr. Ute, it's because it is a little bit different than what we've done before.
Chairman Nicholas, I do have a couple points to make. I will acknowledge that this is, the legislature would be expressly agreeing to delegate some authority, some broad authority to the governor on this. I mean, that is true. There's no getting around that. I think the reason it's worth it to do that and why I think it might be palatable to the legislature right now is because the governor does have relationships with tribes. We have, outside of hunting even, we have a very good, positive relationship with the Eastern Shoshone. It's one that we value. With those existing relationships, with the ability that we have to meet and to speak regularly, we have quarterly meetings with the council. The governor has visited personally Fort Washakie once last year, most likely once, if not one or more times this year. I have the ability to go down and present personally in front of the council if they want. That flexibility, that line of communication, that relationship really allows the state, should the legislature provide this authority, to move on these agreements and resolve these issues quickly and efficiently. In addition to that, statutes granting this authority in other states do exist. None of them really have the protections in there that this one does. And that's what I'm hoping provides the legislature some comfort that the governor does have the best interests of Wyoming conservation, the Wyoming conservation model at heart. These are really the guts, these high-level sideburns of Wyoming's conservation system. And it's in the governor's interests also to negotiate something that, as much as possible, the Wyoming public feels is fair. He has to deal with that side as well, and it is by no means a small hurdle. So I would say, you know, this is a grant of authority, but it's also a weighty responsibility, very weighty responsibility, and one that he takes seriously, which is why we want to bring this bill with partners before this committee for your consideration, knowing that it's a big ask.
And I agree with all of that. The only thing that I'm suggesting is normally the process is he would put together an agreement, he would bring it back to the legislature, and we would essentially ratify that agreement or comment on it. Because the legislature is the ultimate authority of what the laws of Wyoming are, not the governor.
And Chairman Nicholas, I don't disagree that in the past, ratification of an agreement like this was common practice, which is part of why we wanted to bring this bill here, because this would be a departure from that path. I think it's worth it in this instance. I think the risks are worth it. And I would say because of our relationships and our ability and our resources to work on this issue, the governor's willing to take on that responsibility and do it. And I think we have the best ability of moving forward quickly through this procedure. Understanding, of course, it is a departure. I won't disagree with you.
Director Nesbitt.
And Mr. Chairman, if I might have just add a little bit more thought here, and I've been contemplating your question. I think it's a very good one. You know, I've looked at this as some pretty stringent sideboards. And then there's some authority to do some kind of what the agencies do now with drafting regulations. And so there would have to be, and there's authority in this bill for the commission to draft regulations related to any agreement. And so it's not the same kind of a process you're talking about, but management council still would have an opportunity to review those regulations as they do now after the commission passed them. And I think with the sideboards that are in this bill, it does reflect what a lot of other statutes do with providing some, overarching strict guidance that then agencies can go out under the executive branch of government and implement regulations. I think there's some similarities here. That's what.
Go ahead.
Thank you for either Director Nesvik or Mr. Wetland. If we were to go along the lines of what Chairman Nicholas is recommending or notioning in that, we passed this bill, but with another section that says you'll bring it back to the legislature, the rules and the defined agreements will come back to the legislature for ratification or for basically to be drafted into laws to how this will function. What are the ramifications for that if it takes a year, 2 years, or 3 years as we put those rules together and we put those agreements in place and then bring them back to again be ratified or be turned into statute? What will happen?
Chairman Nicholas, Representative Walters, I think there's a couple points to address there. The first one would be it could burden the process in a way that could hurt our ability to speak effectively and efficiently with tribes. We've worked really hard to build our relationship with the Eastern Shoshone Business Council, with the Northern Arapaho Business Council as well. And they are ready, and the Eastern Shoshone have indicated to us they're ready to speak with us. I worry adding another step right now at this stage would create friction and hurt our ability to effectively and efficiently get these agreements through. For example, next session's a budget session. And say there's an agreement that would need to be ratified. To bring that for consideration, you have to reach the vote threshold, since it would not necessarily be a budget item, which may push it to the next session. And so then you could be 2 or 3 years out of getting something ratified. And then say you negotiated an agreement, the governor showed up in the room, we have an agreement, it's signed, the governor and the others, well, not signed, the governor and the tribe is comfortable. We bring it back to the legislature and it has to change a lot. I think that reduces the certainty that a tribe has that they're dealing with the person in the room with the authority to make the deal and that it's final once they have agreement.
Representative Henderson.
Thank you, Mr. Chairman. Wouldn't it be reasonable to expect that the other parties involved in the agreement, although there's a committee established, they would require a period to look at what's been brought up or agreed to and ratified? In simple terms, wouldn't both sides want to have a ratification of the agreement?
Chairman Nicholas, Representative Henderson, I won't speak for the Eastern Shoshone. I want to defer to Vice Chair Ute on that. Of course, I think for our ability to enter into these agreements and get them done, I think it would be most effective for the governor with these sideboards to be able to do that. Of course, that is the legislature's prerogative to grant. I just think the ability to resolve these issues more quickly, given the authorization, and I think it's important to note stringent guidelines that would guide his authority and restrict his authority to things that Wyoming hunters have determined over generations are important. I hope that would help provide that reassurance outside of the ratification process. But I would also defer to Vice Chair Ute. I don't want to speak on his behalf for the Shoshone.
Chairman Nicholas,
Please.
So to address the idea of ratification through legislation, I think we have to remember that this is a federal treaty, right? That it was there before the state of Wyoming even existed. If we add more things to this process of the agreement, are you putting in roadblocks so that the tribe cannot exercise its treaty right effectively? And I fear that would lead to immediate litigation to figure out if you are stopping the tribes from exercising its treaty right. So I would have to disagree with adding any more steps to this than it already is. There's 2 options here. One is to work peacefully with the tribe and do things for the common good. The other one is a judicial conflict, which also adds law enforcement remember with the states or with the tribes treaty right, it does not have to be exercised by the business council or anybody from, it could be any tribal member could say, well, I don't agree with this and I'm going to go off unoccupied lands and I'm going to exercise my treaty right. That then kicks off this judicial conflict. We put those people in harm's way if they don't agree with the game warden that's out there, or somebody calls the cops on them. That could potentially be dangerous. That's what we're trying to avoid here. I think we need to think that this is wholly unique in that it's post Herrera actions. It is not something that we have been doing for the past 30 or 40 years. It's something that's wholly new, and we need to figure out these processes as sooner than later. Okay, if we take years and years, then the tribe might think, well, I think the state of Wyoming is trying to stop us from utilizing our treaty right. And this might in turn lead to litigation. Thank you.
So, Vice Chair, I think that it's important for us to recognize that of the ruling in Herrera case and the fundamental rights that have to be resolved as a result of that case as the law of the land at this point in time. We also want to recognize the impacts and the likelihood of conflict between tribal members off the reservation. If you were in the Bighorn Mountains, or if you're down in the Sierras, or if you're over by Gillette, and the issues that we want to prevent from happening, to have conflicts between individuals and just protect everybody and do this in a manner that is safe and that is open to the public and everyone understands and to assess, essentially to protect reservation members from those folks who may disagree and because the hunting rights of many folks in Wyoming are sacred, just like they're sacred to you. And so I think it, as described by Mr. Wentland, it is a delicate dance for both sides to walk down a path that will not turn into physical conflict, legal conflict, and all of those issues. And so there may be a way that we can move forward that allows for review, but also grants the authority to move forward. And we'll just have to work with this and work with you as we move forward on this. So any other comments that you have or you would like to make before we open up to public comment?
Yeah, Mr. Chairman. So the Eastern Shoshone Business Council and the Eastern Shoshone Tribe itself has been working on off-reservation hunting treaty rights, what we can do, what we can't do. The Business Council has been working, like Mr. Wentland said, was working with the governor. And we do believe that we have a good relationship with the governor. He's at least open to consideration. He's open to negotiation, which is great. I think we are both in the same idea that the tribes can exercise a treaty right and work with the state government without them being diametrically opposed. So we can work together for the common good for everybody if we can just sit down first. And that's where the governor, the talks turn from how do we exercise the right to how do we best efficiently move forward from here. And that's where we're at today. The Eastern Shoshone Tribe, or at least the Eastern Shoshone Business Council, stands behind this bill as is. And the only reason why I say as is because if we start like I said before, if we start adding amendments to this thing and make it longer and longer and longer, then I don't think the tribe can stand behind it, because then it starts to put roadblocks up where we can't exercise our treaty rights, or we have to jump through this hoop to do that. And I believe that'll just lead to immediate litigation or danger. So the bill standing as is, I believe the Shoshone Business Council does support this bill.
Well, and I would just say that the problem with that is that that's not the way that we create laws. And if litigation is necessary, that's fine. But we have to protect our rights the same way you are protecting your rights. And it's the process of making laws is not an easy one. But the key is cooperation and want and believing in your rights, I believe, and recognizing your needs as well as the state needs. And the only way that we can do this is to walk down the road together to get to where we need to go. So we understand, I think, that issue well.
Chairman Nicholas, if I may, I just wanted to jump in on one last point on this. I do agree that collaborating is important. I would also say, though, that the governor does support this bill the way that we've negotiated with the Shoshone. We believe we've really tried our darndest to be through an open, honest process to negotiate this with the council in a way that they were comfortable with, knowing that we would need to speak in these committees and find a way, that kind of a solution that could be mutually agreeable to walk down the path together with and bring it to the legislature. It's the hope that this is that best, most efficient way to do it. In addition to that, I think the one thing to remember in the back of our minds is this has been litigated. It's been litigated all the way up to the Supreme Court, just to be frank. And the Supreme Court has determined under that Crow language that right to hunt likely exists off reservation. And the status quo is likely what the tribes are going to focus on. And that right is there. That litigation has happened. And I think the uniqueness of that ruling and the breadth and the sea change that it represented in the law from what Director Nesvik mentioned before is what puts this in this unique situation where it is a bit of a departure from the normal legislative process. But I think it's one that's merited by the situation that exists and that's been handed to us by the Supreme Court, but that also the opportunity that we've been given to work with a fellow sovereign nation and a partner here in the state.
Okay, further questions? With that, we'll open up the public comment. Anyone who'd like to speak, please come up, identify yourself. Thank you, Vice Chairman. We appreciate your comments.
Mr. Chairman, members of the committee, I am Jess Johnson. I am the Government Affairs Director for the Wyoming Wildlife Federation, and we stand in very strong support of this bill. I think when we look at the larger picture of it, and maybe it is a unique approach, as we've been talking about earlier, but it's also one that I think hunters are very comfortable with, and that most of the time when we're looking at hunting laws and what's happening on the land, we're used to working with the governor's office and the Game and Fish Commission. That's who is doing it. It's not the legislature setting the minutia of this. It is set by a commission that has public input, which we'll have, and it is set on behalf of the executive office. While the law to have that authority is absolutely given by the legislature, the nuance and the details is something that we're very comfortable seeing in the way that it is in this bill. I think the sideboards are important. I think they're very stringent in here and we're comfortable with it. Speaking from personal experience and living in Lander, as I do, we border the reservation, and I have great faith in their ability to manage their wildlife, sometimes more so than other parts. And you drive through there, man, you want to see the biggest antelope you'll ever see in your life. You'll see it on the reservation. They do an incredible job, and they have absolutely amazing partnerships within our own state Game and Fish. They work together a lot. I've been out on bighorn sheep collarings that have happened on the reservation, working together with the U.S. Fish and Wildlife Service, working with the Game and Fish, working with them on teeth shop, looking at how we manage between these two, because as we know, animals don't know lines. So I think the way that this bill approaches this is important. It's important to have that flexibility. It's important to have a broad approach because no one tribe is going to be the same. It's important that we have faith in the ability to sit down and build bridges here. This is an incredible opportunity to come to the table and build bridges around wildlife management that haven't really been built yet. This is a really cool precedent-setting thing. And I have amazing faith. Wyoming Wildlife Federation stands staunchly in support in the ability of our governor, the ability of our game and fish, the ability of our commission, and the ability of the Shoshone tribe and any other tribes that approach us for this, to do this well and to do it right. And, you know, we're here for every step of that thing. In the commission, we have ability for public comment. This is legislation. It is law, but law also can be changed if it's not working for us. So we can come back years down the road if this isn't what we feel like it is and do something. There's opportunity to change these throughout it. And the end part of it where they come, there's a requirement in here to come before TRW committee and report on this, is another place where we can have public comment as hunters. So I think this is a really valuable and well thought through agreement that while it is unique and new, I think it's important. And I think the sideboards here are exactly what we need. And I would love to see this go through as is.
Okay, questions? Okay, any other public comment? Thank you for your comments. Any other public comment?
Mr. Chairman,
Okay, online.
online we have Miss Claudia Washiki.
Claudia Washiki, is that correct?
Yes.
And Ms. Washiki, can you hear us? Can you hear us? Go ahead and speak.
Zambechua, Honorable Chairman and members of the House Appropriations Committee. Nananiha Claudia Washiki. Good morning, Honorable Chairman and House members of the Appropriations Committee. My name is Claudia Washiki. I am an elected official of the Fort Hall Business Council. As a representative of the Shoshone-Bannock tribes, and a federally recognized tribe located in Fort Hall, Idaho, I come before this committee to address the proposed legislation that authorizes the governor of Wyoming to enter into agreements with tribes for the purpose of defining treaty reserved hunting, fishing, and gathering rights within the state of Wyoming. The Shoshone-Bannock tribes were present and signatories of the Fort Bridger Treaty of July 3rd, 1868, forming a distinct political subdivision here on the Fort Hall Reservation, and our relatives, the Eastern Shoshone tribe on the Wind River Reservation. Since July 3rd of 1868, our people have continued to hunt off reservation. We regulate our own membership for those treating and hunting activities, which involved over time management, additional and necessary issues, including issuing tribal permits, bag limits, conservation measures, and recommending seasonal closures for our tribal hunters. Our tribe provides our own fish and game enforcement of our tribal regulations and our big game code, enforcement that extends off the reservation and into other states. A critical understanding of federal Indian law is that treaties are not a grant of rights to a tribe. Rather, they are a reservation of rights by tribes. A recognition that our inherited powers of tribes include all aspects of internal government for members. In a contemporary sense, tribes have sovereign authority to regulate all aspects of reserved hunting, fishing, and gathering under our treaty rights internally for their membership by passing laws, tribal laws, regulations, and harvesting guidelines for each activity free from interference from state regulation. The critical context for this point is that tribes are not required to externally collaborate with any agency prior to implementing any activity protected by a reserved treaty right. In fact, quite literally, the treaty signed between the United States and the tribe is the agreement. Treaty agreements, as stated in the United States Constitution, are to be supreme law of the land, preempting state laws to the contrary. Due to the current status of wildlife management in our homelands, the Shoshone-Bannock tribes have engaged in consistent co-management for natural resources with our federal, tribal, and state partners, particularly for those species that are listed under the Endangered Species Act. The intent of our collaborative relationships with external entities is specifically to ensure mutual agreements and management of natural resources, which is performed substantially and equitably for future generations of tribal members. The unique aspects of our treaty lifeway is to demonstrate our connection to the living world by being good stewards of the environment and those that live within it. The stewardship process is necessarily entails critical evaluation of effects of harvesting limits, population dynamics for the species sought, and long-term trends in populations to determine overall sustainable harvest rates. Each of those foundation concepts are built into the Shoshone-Bannock tribe's approach to fish and wildlife management. A necessary component of effective management includes the need to enforce tribal regulations when needed to clarify communication with those regulations to our partners ahead of each season. While House Bill 83 includes reference to those conditions, it places additional barriers on self-governance that would increase the likelihood of mutual jurisdictional conflicts arising from a single incident. The Shoshone-Bannock tribes have always promoted a cooperative relationship among our federal, state, and tribal partners, but specifically retain the right to regulate the conduct of our membership under the treaty. House Bill 83 appears to set a context that would limit tribes' sovereignty over the management of the reserved right to hunt in Wyoming outside the exterior boundaries of reservations. Rather than acknowledging tribes' inherent sovereignty to manage treaty hunting for the purpose of legislation places sideboards on reserved rights that are not necessarily consistent with the current management of off-reservation hunting for some tribes with ties to Wyoming. The Shoshone-Bannock tribes have never entered into any agreements that would constrain or otherwise impede our management authority under the treaty. And we will not engage in any negotiated agreement as laid out in the proposed legislation. The Shoshone-Bannock tribes remains an active partner and co-manager in the natural resource management across our homelands to ensure the value system is considered by federal, tribal, and state entities. The exercise of reserved treaty hunting, gathering, and fishing substances and traditional purposes. Our conservation-based harvest limits are founded in ensuring those species continue in abundance for future generations. In summary, the Shoshone-Bannock tribes remain unconvinced that the proposed legislation is necessary given the status of inherited self-governance over treaty reserved rights, and would recommend additional fact-finding on this issue prior to deciding to move this out of committee. Chairman and members of the Appropriations Committee, the Shoshone-Bannock tribes are open to further questions and discussions on federal treaty rights in the state of Wyoming. And we strongly encourage that you reach out to us and contact us directly so we can have that conversation and have that open line of communication so we can come to a mutual understanding. I stand ready for any questions. Thank you.
Questions for Mr. Waschke? Any question? So has the Shoshone-Bannock provided any communication or other information during your discussions so far on this project? For Mr. Whitman, in terms of definitions and what their hunting districts were and how that overlays into Wyoming?
Chairman Nicholas, members of the committee, our conversations have been on this topic focused with the Eastern Shoshone. We have not discussed this with the Shoshone-Bannock.
I take it by the wording of this language, it would be the responsibility of the governor to initiate those discussions once this bill, assuming it became law, that would be your directive. Is that correct?
The governor would have discretionary authority to enter into those negotiations and agreements. I think if a tribe approached us and said, we'd like to work with you under this, then that we could start the conversation that way too. But the governor has to, of course, decide that it fits the parameter. He thinks a conversation would fit the parameters of the bill and that he would be within the sideboards.
Do the hunting districts established in the 1800s for the show bands, does it overlap what we consider to be the Eastern Shoshone Arapaho hunting districts?
And Chairman Nicholas, I don't want to speak on behalf of Ms. Washiki or Vice Chair Ude on that. I don't know off the top of my head. The boundaries of those districts, I think reasonable minds could differ at this point, and I don't want to inadvertently speak on behalf of either tribe.
And so if they do, theoretically, you may have two different hunting rules and regulations for the various tribes, and each would be responsible for administering their tribal hunting laws in those jurisdictions. Is that right?
In a hypothetical scenario, that could be the case. Mr. Chairman, what I will say is with any agreement with different parties, there's the issue of, is there variation between each agreement? I think that's the strength of this approach, is that the sideboards here help us try to create a consistent framework that maintains more consistency across agreements through these universal sideboards that would have to apply to each agreement. That guiding force, I think, would help avoid, there still are going to be details, the devil's always in the details, but those high-level sideboards at this stage, the governor's feeling would help prevent more of those variations rather than create them.
So, and we can already see some of the thunder clouds on the horizon. If one tribe, as represented by Mrs. Washiki, don't believe that this current language is necessary and believe that they have operational rights now in Wyoming, and if it moves to litigation, we'll be having one discussion with one tribe and in court battles with one tribe while we try to work with the Shoshones, the Eastern Shoshones, and which could lead to some interesting divergences of opinion and legalisms that will, if we're not careful, would affect each other, basically. And unless, once again, we can dance together, nobody dances. That's part of that. That can be a problem.
And Chairman Nicholas, to your point, I think that's already the problem. That status quo already exists. And I think the ability to do an agreement like this, even if it's just one right now, maybe it's two later, helps us get at that sooner rather than later. Because I think the important thing to recognize is the status quo is Herrera has been decided recognizing with the Supreme Court recognizing the existence of this
So
right.
tell us what the status of Herrera is. Where does it currently lie?
Herrera was remanded after the Supreme Court, the US Supreme Court decided that the 1868 Fort Laramie Crow Treaty hunting rights were not extinguished upon Wyoming becoming a state. That was the main finding. And after that, there are a couple legal issues left that are currently in Sheridan County Circuit Court in front of Judge Cundiff.
What are those issues?
Whether the land where Mr. Herrera was hunting was unoccupied, because the language from the treaty says has the right to hunt on the unoccupied land of the United States, which again, not entirely sure that we have a concrete definition from every court, but it likely means settled with a residence or a building, something along those lines. And then whether regulation of that hunting activity there was necessary for conservation necessity. And that language comes from, it's a term of art that comes from Supreme Court case law in Washington and Minnesota.
Go ahead.
Mr. Chairman, in response to Ms. Washke's comment, she provided us yesterday with her written comments, and that should be in the committee's email.
Okay, are there any further questions for Mrs. Washke? Seeing none, any other online witnesses? Would anyone else like to make public comment? Seeing none, we'll close public comment. We have a motion on the bill. Moved by Representative Larson, second by Representative Walters. Discussion. Discussion. Question being called.
Representative Henderson. Representative Larson.
Aye.
Representative Sherwood. Representative Stith.
Aye.
Representative Walters. Representative Swanser.
Aye.
Chairman Nicholas.
Aye. Okay. So now the process is that the bill will be referred to the floor of the House and be debated on the House, and
Hang on.
we'll hang on. We'll see what happens. All right. Thank you for being here. Appreciate you. Okay, next up is. Where's my list? Good job. Where am I missing? Okay, next. Let's do House Bill 181 and 182. Because these are appropriations bills that we've already worked through the House of the Appropriations, at least some of us who are here. So do we have someone to come up and from LSO to walk through, or actually Representative Walters can, why don't you go to 181?
Thank you, Mr. Chairman. We are on House Bill 181, Online Sports Wagering Amendments. This is, as you said, Mr. Chairman, a Joint Appropriations Committee bill. And so I'll just walk through the bill. If we go to really the issues begin on page 2. And this just defines how we define a free wager in terms of going against the taxable net revenue so that we can make sure the state is getting its full share of what it should be on the tax side. And so previously it said excluding free wagers. We didn't know what was the free wager. And so now we say in the underlined language on line 11, page 2, the actual dollar value of that free wager. And so that way it's defined. Then we move to the bottom of the page in Romanet 15 there, sports wagering vendor, and that's already in definition, but these are the back of the house type of folks in online sports wagering, and we add a few more to that list of who are going to be sports wagering vendors. Moving to the top of page 3, then these are all new definitions, and these new definitions need to be in place as we will refer to them later in the bill, but we have the critical component definition. We will have and then on line 13, we have the key personnel definition. And that key personnel, again, will be referred to later in the bill. Moving on to page 4, this section or the underlined language there is just conforming language that will come up later. And then at the bottom of page 4, it is simply conforming language as well. Moving on to the middle of page 5, we extend the time frame in which the commission has to work through an application from 60 days up to 90 days. And then at the bottom of the page in line 17 and line 22 on page 5, that's simply conforming language again as we clean up the statute. Moving on to page 6 and on page 7, all of those changes I would describe as conforming. And then we move on to page 8 where we had the definition of key personnel, and now here we talk about the licensing of those key personnel and who are those folks in line 2 subsection P. And then again, we have more licensing requirements for employees of the applicant in subsection Q, line 13. And we need these as we have the commission needs those. First, we assess a fee to those people, and then also just to make sure the commission knows who those folks are. Moving on to page 9, this at the bottom of the page is really where the crux of this comes about. And this is in regards to a negative carryover. And there was somewhat of a confusion between negative carryover. We really didn't spell it out in legislation. It was in an early bill drafts, but not in later bill drafts. And then we gave broad authority to the commission to promulgate rules. And in their rules, they came up with how they were going to address negative carryover. And some in the legislature were maybe a little bit concerned with how that negative carryover was being handled. And so starting on line 20, we just define how we will address negative carryover. We allow for it for 2 months. And you'll see that again as it's spelled out on page 10, carried over for 2 months, and then zeroes out. And really the biggest reason you'd have a negative carryover is really in the startup of your business where you offer multiple free promotions. Once you get up and going, that really should never occur again in the future, or most likely won't. And as we look at their statistical data of how that has occurred with their existing vendors, the earliest vendors coming into the market did show a couple months worth of negative carryover. The latest vendors coming into the market have actually not seen that, as there was not a need for as much promotion knowing that it was available.
Go ahead, Mr.
Chairman.
Fletcher.
Representative Walters, on Romanet I and Romanet II, so is it you have two options? You can carry it over for 2 months, or can you carry it over till it's zero, the loss is zeroed out? Is there a difference? Because as I'm reading it, I can see that maybe at the end of 2 months there's still maybe a negative balance that hasn't been zeroed out. Does then Romanet II allow them to carry it on into a third month until they reach a zero? I'm a little confused there.
Great question, Mr. Chairman, and to Representative Larson's question. It's 2 months maximum or zeroed out, and really Romanet 3 is where that's all summarized, saying that you get to one or the other. But at the end of the 2-month period or the zeroing, you proceed, you don't carry over to a third month. So hopefully I answered that to your satisfaction.
Yep.
Representative Larson. Then we move on to page 11, a couple more cleanup items there by adding license. And then page 12 is just making this effective immediately as the enacting date.
Representative Henderson.
Thank you, Mr. Chairman. Going back to the page where they're talking about the loss. I wasn't here this last interim, but I'm having a little trouble understanding what the significance of that is in terms of, is there a lot of losses that makes a big deal, or what's the need for that?
Thank you, Mr. Chairman and Representative. The reason a loss occurs typically is based on promotion. And so they offer more promotion than they actually bring in total revenue. The loss does not typically come from wagers and overweighting of wagers one way or the other, but it could potentially come from that. And so this is how I think 17 of the 22 states that offer online wagering addresses this is in some way similar to this, to allow for a small amount of carryover. Sometimes in some instances, it's an unlimited carryover. Others, it's a 1 month, 2 months, 6 months. And so as we worked on this and finalized it in October, we kind of tried to find a averaging of what other states are doing, you might say.
Okay, I'm going to ask Director Moore to come up and just kind of walk through this bill and the need for it and kind of summary of your your testimony during the interim, Director Moore, if you could.
Good morning, committee members. My name is Charles Moore. I'm the director of the Wyoming Gaming Commission. I have with me today Nick Laramendi, special agent, and I also have David Carpenter, who is sports wagering program manager. I think if you'd like me to start off and explain some of the negative carryover, is that what you'd like me to start with?
Well, first, I'd like you as director to tell us about whether you agree or disagree or and what the need is for this bill.
Okay.
These amendments.
Yeah.
And then we can go into the specifics.
Thank you.
And how we got here today, basically.
How we got here today. Thank you. Yes, I brought this came to the attention of the Joint Appropriations Committee in interim this summer. And as far as on the first part of the bill, on pages 2 through, most of that is all licensing. And to be consistent with other states, we had approached the Appropriations Committee and gave you suggestions of adding a few of these categories into licensing. So we were more in line with the states to the south and other states in North America. So that's where that came from. As far as the negative carryover, which is starts on, I believe, page 9. What I might do is have David Carpenter kind of explain that to the committee and how we came to that point. David?
Do we have a question on that, Mr. Chairman?
Did you?
I think that
Okay.
will explain.
Okay, thank you. So back to the original question, the licensing categories, we're fine with those. We feel like those are appropriate, what we had looked for. And the negative carryover, it's a minimum. It's a minimal amount, and it is happening and being dealt with similar to this, to what you've proposed here. In other states, right now, I believe we have 19 out of the 22 states that do allow for negative carryover, and the bill, I think, captures a lot of that language and helps. So as far as we are in the position, we're in favor of this.
Okay. Public comment. You got any public comment on the bill? Public comment. Going once, going twice. Okay, we'll close public comment. Is there a motion on the bill? Moved by Representative Larson, seconded by Representative Walters. Further discussion on the bill.
Mr. Chairman,
Representative Stitt.
just want to say thank you to Director Moore and Mr. Carpenter for working with us on this. And I think we have a good product.
Okay. Any further discussion? Seeing none, roll call.
Representative Henderson. Representative Larson. Representative Sherwood. Representative Stith.
Aye.
Representative Walters. Representative Swanitzer.
Aye.
Chairman Nicholas.
All right, next we have House Bill 182. Representative Walters.
Thank you, Mr. Chairman. We're on House Bill 182. Again, a joint appropriations bill. We voted on this as a joint committee in our October meeting, so it's been a while since the members have seen this, and the new members may not have seen this. But it'll start, the meat of it really starts again on page 2 here. We have some new definitions at the top of the page as to who defining directly involved and the people that we consider directly involved, as well as a new definition for manufacturer. And then as we move down to the bottom of the page, we just clean up the old language and remove it that discusses the provisions from 2020. And really it shifts some of that away from who was operating in 2020 to discussion of who can operate today. Then we move up to the top of page 3, and it really says about the same thing, except it's a cleaner statutory reading of it. Yeah, on the top of page 3, moving down to the bottom and line 16, Romanet 3. This is a new list of people needing licensing. And then on line 21, we have a manufacturer's license. So this way, if a manufacturer of the game, they would be able to be licensed. And that way, if multiple users, purchasers of that game would not all have to go in to get a license for the same game, saves everyone money. But you'll notice on the top of page 4, we charge a pretty hefty fee for that licensing of the manufacturer. And the reason we chose to do that is we said, it was kind of like a gold ticket for the manufacturer because they were approved for multiple folks to be able to offer their game. And if they were going to have that large approval, that we should charge a little bit more. Otherwise, the state doesn't make as much coming off the permitting of those, because currently the state would charge each applicant that came in to require those games a permitting fee. So that was our reasoning for that. And Romanet E is the lab certification on those games, that they can't be manually activated or altered by the vendor. And then at the bottom of page 4, we extend that application period 60 days out to 90 days for the commission, and that's the gist of the bill.
So again, Director, why don't you come up and discuss your need for this and your recommendations on the bill.
Again, thank you very much, committee members, for having me here today. We worked on this bill throughout the summer, as you all know, and I think this is a very good compromise. I think it's capturing what we need, the additional tools in our toolbox to regulate the industry. I think it's very, the approach is from the commission side of this is to not be punitive, to be proactive. I think it's very important in the gaming world to try to be proactive. So we're capturing that with the licensing of some of the key employees. So that's all I have at this point, if that's satisfactory to you.
Were you having problems with this? Why did this come to the fore?
Thank you. Chairman Nicholas, and the question is, have we had problems with this? When you're dealing with a cash business, completely a cash business, the individuals that are touching that cash, and this is consistent in all gaming jurisdictions. If you're handling that money, you're touching that money. And a lot of these people they're not in a setting where there's 20 or 30 people lined up next to them that are monitoring and overseeing this. These people are collecting cash. They're out there in the field collecting cash. It's a very proactive approach to overseeing this and trying to keep, individuals out. It's accountability with that in trying to get ahead of it and try to at least filter out some people that maybe don't have the business in there touching that cash. Did that answer your question?
I think so. And then just to follow up on if you go to page 3 and 4, we talk about the sums for licensing fees. How did you come up with those figures and what was the input of the businesses in developing these figures?
Yes, thank you, Chairman Nicholas and committee members. The $50 fee that's on line 19 of page 3, that's capturing our background check and the fingerprinting costs. That basically is what that's doing. And we're not necessarily in a position to where we want to be trying to make money. So that's just trying to recoup that cost, our hardcore cost with that.
And Mr. Chairman,
Go ahead.
thank you, Mr. Chairman. If I could interrupt there. So those folks on page 3, little III, these folks are actually handling the money? They are handling the money, but excuse me, but do they have access to be able to change any of the gaming electronic parts? And so my question is the need for this extra $50 if the people are just working and collecting money.
Go ahead.
Chairman Nichols, Representative Zwansker, the way that this is written and the way that we're seeing it, it is a vendor's employee. So the vendor's employees are the ones that service the machines, have access to the inner workings of the machine. That's the people that we're trying to capture, is just the vendor's employees. They're kind of the frontline people that are out there dealing with customer complaints. If there's a problem with the machine, they're the ones that go on the route and service the machine. They pull the cash from the machine. They can fill the machine. They run the reports from the machine. They're really the persons that are kind of the front line of the whole thing.
Go ahead.
Mr. Chairman, to follow up, if I can hit my button. But the vendors are not the manufacturers, and should not only the manufacturers be the ones that would be able to go in and reprogram the payout? And so I understand that these are employees of the vendor, but if their simple job is just to collect the money, and I questioned if they actually have access to the inner workings of the machine. That's my real question.
Chairman, so it kind of depends on the manufacturer. Some manufacturers have total control over their devices. Other manufacturers sell their equipment to a vendor, and then the vendor has total control over that product because they own it. So it all kind of varies depending on the manufacturer and the product that they're offering.
So, Mr. Chairman, the person that owns the machine can actually go in and tinker with the payout. So they can make it a 25% payout compared to a 90% payout.
In some cases, the vendor or the vendor's employee could manipulate a game to where the payouts are different or the wager amounts are different. Again, it all depends on the manufacturer and what they offer. So it's different amongst different manufacturers, but this kind of covers the general consensus of the entire industry.
And one more follow-up. So does it matter what the game is? So, I mean, if you got a golf game on there as compared to a random chance sort of game, as to if those people have access to the inner workings or they don't?
Go ahead.
Mr. Chair, I don't think I understand your question completely, but all of these games they're just strictly skill games. So there's no real chance involved. A player can exercise skill 100% of the time and win 100% of the time.
So I think our general discussions during the summer were anyone that can take off the back of the computer and has access to it, whether or not if it's an employee, they have the access to the machine. They may not have the sophistication, but it's just protecting all those folks that have access.
Okay. So, Mr. Chairman, a vendor's employee could change the game from making it where you do have 100% possibility of winning to making it where you do not have 100% probability. That's my question.
Mr. Chair, I don't believe that a vendor's employee could change it that drastically to where they could essentially turn it from a skill game into a slot machine, if that's kind of what your question is. But the person that is in that machine is accountable to withdraw the money and run the reports and report that back for the taxation purposes.
Okay, further questions? Any follow-up? I mean, continue, Director, as you walk through these. Now you've got the next.
Yes, thank you,
Manufacturer
Chairman
licenses.
Nicholas. And back to maybe just the previous discussion, just briefly. If you go back to page 2 and read the definition of directly involved, means any person who maintains services or has access to the inner workings of a skill-based amusement game provided by the vendor at a permitted establishment in Wyoming. I think that may help to clarify some of those questions. I'm seeing the head shaking, but so then if we
Go ahead.
Yeah.
Mr. Chairman,
Go ahead.
I had a question for Director Moore on page 3, line 17. I believe it's the same issue. We have the phrase, an employee of a vendor who is directly involved in the possession or distribution of skill-based amusement games. My question is, if we deleted the phrase possession and just had it involved in the distribution, how would that affect the application of who has to be licensed?
I don't think that would create Chairman Nicholas, Representative Stiff, I don't think that would create any problem. If that's.
Further question? Okay, please continue.
Thank you. Moving on page 3, lines 22 to 23, and then on to the next page. We're dealing with the manufacturers. In the summer, when we worked this, this mirrors the manufacturer's $10,000 license fee. I believe we got that from the District of Columbia, I think it was. And that's why we utilize that. Moving on then to, I believe then on page 4 also, lines 5 through 11, that was a suggestion that had come into play from one of our skill-based amusement game applicants in the state. And that's all I have really at this point in time, Chairman Nicholas.
Okay, further discussions, further questions? Go ahead, Director.
Mr. Chairman, on page 2, the definition of manufacturer. Can you give us an example of, for a given skill-based game, let's imagine we have one party that's involved in making the screen display, another party that's involved in manufacturing the cabinet, another party that's does the electronics for it, for example. And then they're all sent to some facility in Mexico where they are assembled. Under the current definition, it sounds like all of those people are manufacturers. Is that how you understand this? Or is only the factory that does the final assembly the manufacturer?
Chairman Nicholas, that is how it reads. I don't think that's what we're hoping to intend it to mean.
So
No.
I would disagree. I would say that that's not how it reads. I think it says in the business of constructing skill-based amusement games. So that's a final product. So that's assembling various components that make a skill-based amusement game. It wouldn't be whoever provides the copper wire. Go ahead.
And I agree. So if I was in the business of making cabinets for video games, that might include cabinets for a skills-based game. So I'm a cabinet maker, an industrial cabinet maker. If I'm in the business of developing computer software for a variety of things, one of those might be for skills-based games. I don't know that I'm in the business of building a skills-based game. I would agree, Mr. Chairman, with your assessment of it, that this is talking about that final assembly of all components to have an end product being the manufacturer of skill-based games. That's just my opinion.
And to follow up on that, if it's an issue, I think that could or should be resolved through rule and reg in their definitions.
So, Mr. Chairman.
Go ahead.
So Director Moore, having said that, would you anticipate if this passes in its present form that the rules and regulations would reflect that understanding?
If they so choose to, or if they find a need to, yeah. I would say yes. Okay, further questions? All right. We'll open a public comment. Come on up, anybody would like to have public comment?
Good morning. Chairman Nicholas, members of the committee. My name is Ryan Clement. I'm here representing Patriot Games. So we're one of the licensed vendors in the state. Also smoker friendly. They have 8 smoke shops as operators, and Dillinger's, which was the place of business that I owned downtown here that operated for 2.5 years, that had skill games, that was ultimately bought out by the Horse Palace Casino on Central and Lincoln Way. I'm here to talk about mostly this manufacturer's concept and especially the definitions. The way that I read it, Patriot Games licenses software from an outfit in Florida. We buy our computers, screens, and bill acceptors and things of that nature from a different, we call them vendors. And then all of those components go to a facility, the cabinet maker, that puts all of those things together and ships it to us. And then we take those games and, under the contracts we have with our operators, distribute those games around the state. We also have games in Nebraska. I think we have 27 games licensed here. I think we have 20 games in Nebraska. There's no manufacturer license fee in Nebraska. The fees, there's no competition with historic horse racing in Nebraska. And there's no 20% off the top for taxes in Nebraska. So all of those things exist here, 20% already off the top. We already pay fees at $2,500 a year to be a vendor. And we have to compete, obviously, with an unfettered, expansion of the HHR group. So under these circumstances, the way that we read it is that each one of those, the licensing of the software, the purchase of the computer and the screen from the vendor, and ultimately the purchase of the cabinet and the construction of the cabinet, we could be looking at $45,000 theoretically just to get out of the starting gate. And I can tell you, with only 27 games here in the state, which 4 of them are down right now because my games at Dillinger's aren't operating because Dillinger's isn't in operation right now. Now that is extremely onerous. And again, the definition of manufacturer doesn't exactly fit what we do. So, I would urge that we use this as an opportunity to work with the Gaming Commission on rules-based approach to this, because we're fine with the employee licensing fee. And I would be fine with the concept that there would be another fee, another classification, because really we don't fit under the manufacturer's definition. I don't think, based on what this says in the bill. So either way, just taking this, going back and working with the commission, I'm happy to work with Director Moore and Mr. Laramundi, and I understand Mr. Laramundi's concerns about the employee concept. I'm all of these things. I'm an operator. You could think of me as an employee. I'm a vendor, and theoretically, I'm a manufacturer. And so this touches every part of what I do within the context of the current skills-based amusement games legislation. So again, I would urge to vote no on this bill and the amendments. But ultimately, if that doesn't happen, I'd hope that we could kick this back to working with the stakeholders of the Gaming Commission. That's all I have.
Okay, questions? Go ahead, Representative Stitt.
Mr. Chairman, so sir, tell me in the example you gave, if there were a fee to license a manufacturer, and if that, let's assume that that fee were something that was more palatable to you, who do you think the party in the chain of production should be who gets assessed or licensed as that manufacturing fee? Is the person who last touches the product before it gets shipped, or is it someone earlier in the production chain?
I might defer that question to some of my colleagues in the stakeholder community. I think some of us are just built differently. I think the intent would be for from Gaming Commission and the language in this bill would be for us. Ultimately, the people that have the game and have the license, as Representative Walters suggested, we have a license to go put skill games out. Not yet. We've been under a 2-year, 3-year moratorium. But here soon, we hope that we can go put more skills games out. And I think that license to do that is kind of what's suggested. It would be the then accelerated regulation on top of regulation for us. I think that's the intent, because I don't know how you could go to any one of the particular licensees or vendors that we use to put it all together and say, you owe $15,000 to do business in the state of Wyoming. They would just say, okay, you pay it or we're not doing it. That's the way that would work. So ultimately, if we're going to change the vendor license to a manufacturer license, or if there are two different entities out there, a vendor and a manufacturer, then maybe that just needs to be addressed. In my opinion, and I think I would defer to Director Moore and Nick, but I think I heard testimony the other day that $1.8 million from skills games is going to schools, about $1 million is going to the counties, about $800,000 going to the cities, and then gaming is doing about $420,000 just from this past year of skill games operation. I don't necessarily know why we have to do another $10,000 fee on top of that. I think skills is paying their due share, where it's at.
Other questions? Okay, appreciate your comments.
Thanks.
All right. Any other public comment? Come on up.
Good morning, Mr. Chairman, members of the committee. Catherine Wilkinson here today on behalf of Cowboy Skill and Appropriations. Here to respectfully ask you to stand in opposition of the bill or consider tabling the bill. What you have before you in House Bill 182 is an agency solution for a perceived problem. There are 40 pages of rules sitting down on the governor's desk that have been very thoroughly vetted, and we're awaiting his signature so that we'll be able to expand. There are pieces of this bill that I think that we as the industry can sit down and work with the Gaming Commission on. Appropriations is in support of a manufacturer license, but there's another piece in here that's missing, distributor. So there's 3 versions as we see it. However, after hearing the testimony of my colleague, I think that the definition of manufacturer is not quite set, where we don't want to be excluding other small businesses in the state. Excuse me. We need to find the right Wyoming solution that allows everyone that is currently licensed to work in this arena. Mr. Chairman, specifically on the bill directly involved, I have yet to see how licensing and having a background check for an employee is going to prohibit the tampering of the machines and the software. The employees of the vendors, so the vendors usually are the front faces of the skill games. The majority of my folks that I represent, which are 7 small independent companies, are licensed as vendors. Some of them have 1 or 2 employees that do the cash-based route that may collect the cash boxes. They may go in and do some maintenance on the machines, but they do not have access to the inner workings of the software. That is a completely different thing. The way that the Pace-O-Matic games are set up, there is a dongle for the software that has come directly from the manufacturer that is lab certified as part of the licensing process, that it cannot be altered. If anyone tries to remove that dongle, the entire game shuts down and cannot be restarted except for by the manufacturer. They are licensed dongles to the machine specific with TID numbers. So I'm not saying that anyone who was really, really nefarious in trying to get in couldn't figure out a way, but I'm saying the average employees, that this is government overreach if there's no need to license these additional people. I would also have you look at the fiscal note of that. I'm not sure where the 100 estimation is coming in of those vendor employee licensure. I mean, if you were, maybe, I guess with all the vendors, and that's an estimate for all the other incoming, excuse me, incoming companies, but I do think that that is high. It's not a cost prohibitive with the $50. I just think that it's onerous regulation. So I'd like to remind you, we did come to the legislature seeking regulation, but we do feel that this is a little bit of overreach of regulation. Lastly, on page 4, that was the issue that we were trying to get with to address the Gaming Commission's concern about the employees tampering with the machines. I think that this is already taken care of in the licensure report that is done by the independent laboratory when our games come into the state, that they have to certify that they actually are a game of skill and cannot be tampered with. Mr. Chairman, I guess I would ask you to oppose or table this bill. We have a couple of meetings coming up with the Gaming Commission and ask for the time and authority to be able to sit down and see with these new rules that are being implemented, what needs arise with this industry. There's a heavy regulation. We work very closely with them on the rules, and I just don't think that this piece of legislation is getting to, there are no issues. We've been operating very successfully for 4 years, so I would stand for any questions. Thank you.
Questions?
Catherine, on page 3 where you talked about, well, I don't know if it was on that, that's just where my notes are, but you talked about that Pace-O-Matic, you can't come in the back of Pace-O-Matic and be mischievous and do that. But is that consistent on all brands? I mean, so are you speaking inclusively of every kind of manufactured skills-based game, or are you only speaking for Pace-O-Matic?
Mr. Chairman, I only have knowledge of the Pace-O-Matic game, so I'm not speaking for all industry.
So, Mr. Chairman, follow up then. So as we try to put these protections in there, we acknowledge that Pace-O-Matic may be tamper-proof, but until we can verify that all games are tamper-proof, you see what I'm saying? That's why I'm asking the question is if you had knowledge that all are tamper-proof or if it's just Pace-O-Matic. And if I'm understanding correctly, you're speaking the Pace-O-Matic is, and we may not have, at least with those who are here today that to testify, that could confirm that others are equally as tamper-proof.
Excuse me, Mr. Chairman. So yes, I understand the question, and on behalf of Pace-O-Matic, what I do understand is the process that you as a legislature have already laid out in law. So what that requires is for any of the games to come into the state, they have to be authorized and certified by a third-party laboratory. There are only 4 of them that are independent laboratories in the state, and they test the software to be sure that it is a game of skill, that they can't be flipped to a game of chance. What I don't know is I don't think they check with the tampering, but I would assume that with that software, part of it is ensuring to make sure that they truly are games of skill. So, Mr. Chairman, I can't speak on behalf of the other companies, but I do understand what you're saying. I do think that there are a lot of safeguards in place, though, that would prevent the need for this sort of specific language in the.
So the question is, if we need to tinker with the definition of manufacturer, there's a certain logic to that. You guys had 2 months to make amendments and bring them to us and describe it with us. And my question is, why haven't you done it? these bills are sitting out there. We had testimony on it, and instead of killing it, you and worked with the director. Now you're saying just kill the bill. And I suggest that we could table this a day if you want to bring amendments to us tomorrow, because that's a pretty simple fix. I mean, it's the end user, and we could define that in a way that would, I think, facilitate your issue and your issue on that definition. I mean, are you opposed to doing that?
Mr. Chairman, Pace-O-Matic is fine with this definition of manufacturer. And I believe our colleague, I don't think was involved during the interim. So that was the reason for the testimony of being sure that, you know, we weren't fencing anyone out, that it was currently doing business. And I do hear his concern. As I said, there's another piece that I think is missing from this, and that is the distributor. You've got manufacturers, distributors, and vendors as defined currently in law.
That makes sense to me. I mean, but to add a distributor definition would be pretty simple. Would it not?
Mr. Chairman, members of the committee, if I may. I was at the skills games meeting in November when we were going over the technical standards for what was coming up, for this session. I was literally indisposed in December. I was completely out of the country. So when I got back and I saw this bill, this was the first opportunity that I had to address it. So I apologize to the committee and Mr. Chairman for not getting to this earlier. I wouldn't be opposed to an amendment, just to the amount that we're talking about for manufacturing licenses, and then also a definition that would better define the marketplace that you have in distributors, manufacturers, operators, and vendors. There's a lot of different definitions there, and I think that a tighter definition on manufacturer, and then I can work with my colleagues to address the rather onerous fee amount for us that maybe isn't so onerous for them.
So, I mean, the testimony was that these fees weren't onerous. They were consistent with a lot of what are the other states charged. But I do think that if we're stacking fees, that's a different thing. So what I would suggest is that, I mean, you've got lobbyists, you've got folks here to put language together. We'd be happy to table this and address this tomorrow afternoon or at some time. We've got to do it in the next couple of days, but go ahead.
So, thank you, Mr. Chairman. I'd like to come back because as I look over here and see Pace-O-Matic, I see us ordering a Pace-O-Matic machine delivered, completely manufactured and put together. I hear your kind of a definition of manufacturing may mean as an independent. You may put these together. A distributor may put these together. I don't know. Can you help me through that manufacturing bit from your perspective again?
Yeah, sure. So the software itself, the way the game actually plays and the software itself comes from a license. We license that software.
So I get that. I get the different components. Who's putting them together?
Ultimately, it comes from the cabinet maker that puts everything together and sends it to us.
And who's us?
Patriot Contest and Games.
Okay, so
the vendor.
Patriot.
Yep.
Just walk me through this. So Patriot is kind of the same as a Pace-O-Matic.
Yeah, we have a vendor license in the state.
Okay.
So frankly, your description does not really make sense to me. You have to have someone who's putting all the strings together, who controls about the software, and just because you have someone else put a box on it doesn't mean that they're the manufacturer. That's a subcontractor that finishes the product. But there ought to be a way to resolve this. I don't think it's that complicated.
It may not be that complicated. It was just the language that I read. That's what it looked like to me. So I'm happy to work on an amendment to tighten up the language.
Okay, yeah, it's 10:11, so I think we'll table this till tomorrow and see if you guys can get together with the director, if we can find some something that makes sense.
Sounds good.
All right. Thank you. With that, we'll stand in recess. We also have one more bill, which I think as we announced that that'll continue over now to an adjournment. And what is that, number 27? School facility consolidation mediation schedule. And then
Yes.
we also have scheduled bills 183, 184, and 185. So we'll see everybody